Well, whether a data breach is large or small, we should always be concerned about litigation. You can't think about litigation, though, for the first time after the data breach notification letters go out. Even though the defense bar has had some good wins in 2010 and recent years with the Hannaford decision, Gap, and Starbucks, these cases are very costly to litigate, they're very factually specific, and the company's reputation is on the line. And in addition to the people that are affected by the data breach, we're seeing more and more lawsuits by regulators. These are increasing each year. At Marshall Dennehy, when we counsel our clients as they go through a data breach, we tell them, don't just focus on getting the letters out the door and into the mailbox, but take a look at each of the steps as you go through the notification process, because it may impact how you defend a claim later on. What is being said in the notification letter? How is it being said? How's the call center answering questions? Are you offering credit monitoring? And if you're not offering credit monitoring, why not? How difficult is it to find out what information is affected and who's been affected? The answers to all of these questions are going to impact how you defend a lawsuit. The defense bar got a few good wins in 2010 with Hannaford, Gap, and Starbucks, but the cases are still very expensive to litigate. And the courts are looking at these cases and they're saying, if you have lost time or you have fear of harm, that's not recoverable. So the pendulum hasn't swung totally in favor of the plaintiffs yet. But with more and more companies handling data breaches with outside help internally, and more attorneys who are not knowledgeable in this area getting involved, we're seeing more and more data breaches being handled sloppily, which is only going to allow the plaintiff's bar to become more creative and file lawsuits. The dust isn't settled, it's just being stirred up. Even with these recent wins by the defense bar in 2010, a company's reputation is being judged and evaluated. But there's another group on the move, and that's the regulators. We saw last year in 2010 an attorney general file an enforcement action under high-tech. We saw another attorney general file a lawsuit because the company took too long to notify, in his opinion. And now in 2011, with the enforcement authority given to FTC under the red flag rules, we're going to see even more regulatory actions. We live in a global economy, and more businesses are doing business outside of the U.S., whether it's retail, financial, or even healthcare. And many countries have privacy laws, whether they're through legislation or interpreted through their constitution. And last year we saw Alberta, Canada, and Mexico institute data breach laws that are going to affect U.S. businesses. With 46 state laws that are in effect currently, a 47th law going into effect later this year, being regulated 6 ways to Sunday, and now with international privacy laws, there's enough creative lawyers out there that are going to make this all very interesting.